morning, everyone. I'm going to go ahead and get started. I think there may be some more that get added in the next few minutes. I have turned on the chat bar, so I can see on there if there's any questions that people have as we go through. My name is Matt Christensen. I am the managing partner here at Eastman Johnson. My practice is largely finance related, bankruptcy, real estate, that sort of thing. So that's why I got tasked with the small businesses and some of these new stimulus bills that apply to them and the loan products that are coming out. So I will go over some of the small business aspects. We did a similar class about a week ago, so I'm trying not to rehash everything from there. The disclaimer I always have to give, and we've done these with most of the classes that we've done, this is I'm providing general advice. It's not specific to your situation. It's for informational purposes only. We're not actually creating an attorney-client relationship by your viewing of the video. We always, of course, welcome specific questions and specific circumstances. We're happy to speak with people outside of the class. So this is part of a series that we're doing. There's a couple other classes we've already done that are available on our firm's website and as some of the social media platforms. Last week there was an employment issues and COVID-19. There was also real estate issues, landlord-tenant issues on the same impact of COVID-19 on those things. Those two classes are available. This class and the one previously done on small businesses is also being recorded, will be available on the websites later today. We also have two more upcoming this week. There is one on Wednesday afternoon at approximately 4 o'clock. That is being taught by Nathan Fowler, one of our attorneys with a tax background. That class on Wednesday is specifically the tax issues and COVID-19 stimulus bills. And then we'll have an additional class on Friday at 12:30 during lunchtime, which I will be teaching again on bankruptcy issues that may arise from the COVID-19 situation. And that will generally focus on businesses, but we may have some aspects for individuals themselves as well. So those are the upcoming ones. We encourage you to phone in for those as well as the ones that we're doing today. So I'm gonna start just kind of generally with the background on the various relief acts, stimulus acts that have been passed by Congress, signed by the president. There's one fairly specific that we'll discuss for today, and some additional guidance that's come out from the SBA on those small business loans. So the first bill or loan product that I'll discuss is what's known as Economic Injury Disaster Loan Program. This is a program the SBA's had in place for quite a long time. When specific disasters arise and are declared as disasters, then those funds become available. It's a loan program through the SBA. It's a little more restricted and limited than the PPP loan, which I'll discuss in a bit. But these loans can be for a much longer term. So the maximum amount of an economic injury loan is $2 million. It's repayable over approximately a 30-year period. Interest rate is 3.75% for for-profit businesses, 2.75% for nonprofits. Generally, this sort of loan, if it is more than $25,000, requires some sort of collateral, personal guarantee from the owners, and is nearly always available to business owners. If a business got an economic injury loan after January 1st of this year related to the COVID-19 issues, this sort of loan can be refinanced into a PPP loan, which is the forgivable, no guarantees, that sort of thing loan that we'll discuss in a little bit. So if you already received an economic injury loan, that is something that you could refinance into a economic injury loan or excuse me, a PPP loan and get a better terms than the current economic injury loans would be. So that gets to the sort of the meat of what we're discussing today, which is those payment protection loans. They've sort of commonly become known as PPP loans. These are loans that specifically come from the CARES Act, Coronavirus Aid, Relief, and Economic Security Act, which was passed just under 2 weeks ago by Congress and signed by President Trump. These are the loans that are available to small businesses, which are defined as businesses with less than 500 employees, and that's 500 employees per location. So if your business has multiple locations, potentially as a whole, you could have more than 500 employees, but you would still qualify if they're in multiple locations. You have to certify that you're currently suffering uncertainty because of current economic conditions, and the loans necessary to support the ongoing operation of the business. I'll cover a couple of additional things that you're required to certify in the actual loan application in just a bit when we get to some of the current guidance. These loans are up to $10 million. Generally, I think most of them are going to be less than that because they're also limited to 2.5 times your payroll costs for the last year or so, depending on what type of business you are. So 2.5 times average total monthly payments for payroll costs, or $10 million, whichever is lower. The bankers I've spoken with generally seems like these loans for small businesses, at least locally here in Idaho, are less than 100,000 that people are trying to borrow. Payroll costs is a defined term. There's still some confusion about what all it includes, but it definitely includes any salaries, wages, commissions, tips, vacations, sick, severance pay, any of those sorts of things that were paid within that 1 year period. It includes group healthcare benefits that the employer is paying, including the premiums for those things. It includes retirement benefits. So if an employer is matching an employee's contribution, those matching retirement benefits. Also includes any state or local taxes paid on those employee costs. What's still sort of up in the air and somewhat in confusion is if you are an employer who pays both employees and independent contractors, 1099 contractors, does the payments to the 1099 contractors also get included in those payroll costs? There's conflicting language in both the Act and the guidance from the SBA on whether those are included or not. So that's an issue that still will have to be resolved and likely will be up to the bank that you're using to determine whether or not you can include those costs. Things it does not include: any federal payroll taxes that are paid either by the employee or the employer, any compensation over $100,000 per year for any sort of employee or owner or independent contractor or sole proprietor or anything like that. Any payments made for anyone who resides outside the United States, and any payments made to employees based on the Family First Coronavirus Response Act, which is sick leave and sick pay that's paid to individuals who have to remain home and or who have children that they are out of school, so they have to stay home and are getting paid under that program. Those payments would not be included in a PPP calculation. There are some specific uses once you receive the PPP funds. What can you use those loan funds for? generally payroll costs, which is the same thing we just discussed, lease payments, mortgage interest payments, but not the principal payments, other outstanding debt obligations, again, just interest payments, and utility payments. One thing that's interesting, especially for those with a lot of leased equipment, the lease payments are not limited to real property leases. So if you have equipment that's leased, you can use those funds to pay some of those equipment leases as well. If you are going to be seeking forgiveness of any portion of the PPP loan, I recommend creating an entirely new bank account. Whether it's a savings account, checking account, doesn't necessarily matter, but some way that you can actually track those funds and what they were used for. If the only thing that ever went into that account was the loan proceeds, and then you can track what you use those funds for, that's what you're going to need to be able to do to get the full forgiveness or the maximum forgiveness under that loan. To the extent you use the loan proceeds for payroll costs, rent payments, lease payments, those interest payments on mortgages, utility payments, then the loan will be forgiven. Or you can apply for forgiveness, and the bank will determine whether you use the funds for those qualified purposes. Assuming that you did, the loan funds are forgiven. You don't ever have to repay them. These loans are 100% guaranteed by the SBA, so that's why they can be forgiven. The bank then turns to the SBA and asks them for the repayment. There are no collateral requirements for the PPP loans. There's no personal guarantees by the owners. It's a fully non-recourse loan. That's because the SBA is 100% guaranteeing that. Since the original statute was issued, the SBA has issued some guidance to borrowers and lenders on what you can use the loan for, a little bit more guidance on what you need to apply to the bank, the applications, that sort of thing. So I'm going to go over some of the highlights from that rulemaking process from the SBA. For those who aren't familiar with the way the federal government works, Congress passes a statute, but then the executive branch agency has to go through and issue guidance on, well, here's how we're implementing the statute. That's done through a rulemaking process. The SBA on this past Friday issued the initial or interim final rule for these PPP loans. It will become final after there's a comment period and this sort of thing that they have to statutorily go through, but they have made the interim final rule effective immediately. And so the banks that are processing the loans are using this as guidance for how to process them, what they can be used for. The first documentation, obviously, is a loan application. I've seen the loan application that the SBA promulgated or sent out. It's 4 pages long, and 2 pages are just recitations of federal statutes that you're confirming that you have read and agreed to. So in essence, it's 2 pages. The second page is the signature page and contains all of the certifications that the signers have to make. The first page is really the meat of the whole thing. In that application, all of the owners of the business who are applying have to certify certain things. So you will need a signature from every person that has an ownership interest in the company. They have clarified that e-signatures are okay. They don't need original signatures for the loan applications. And I'll get to what some of those certifications are in just a bit. In addition to that loan application, they also are going to require documentation of the amount of the loan that you're asking for. Those documentation will include payroll records, payroll tax filings, so the 941 filings that you would send to the federal government, any of those sorts of tax returns, 1099 forms if you have 1099 employees. If you're a sole proprietorship, so you don't necessarily have those sort of things, just a statement of income and expenses. Just the bank will need something to be able to verify the payroll costs that you're requesting a loan for. If at the very least you can pull up bank statements and show them bank statements and identify what the payroll payments were for. So on that application, the certifications that have to be made are first that you were in operation on February 15th, 2020, and that you had employees that were being paid and or people that you were paying as independent contractors. You have to also certify that the current economic uncertainty makes the loan request necessary to support your ongoing operations, and also that the funds will be used to retain workers, retain employees, make payroll, or those other authorized expenses. You will, like I said, need to submit with that some sort of documentation verifying the full-time employees on the payroll, and again, that you won't use it for any of those unauthorized things. The owners of the company will also need to certify, and this is why they have to have all of the owners sign the document, that they are not incarcerated, on probation, on parole, that they haven't been, they're not currently under some sort of indictment or criminal charge, and that they have not been convicted of a felony in the past 5 years. If any one of the owners cannot certify that, then you will not qualify for the loan. Additionally, if the business or any owner or any other business owned by any of the owners has or had a different SBA loan or SBA guaranteed loan that is currently delinquent or was previously defaulted and resulted in some sort of loss to the government, then you also will not qualify for the PPP loan. A couple other things on the rule that came out from the SBA that also will disqualify you from those loans. They have accepted what they're calling household employers. So this would be an individual who hires, has like a full-time maid or a full-time nanny, that sort of thing. Those individuals do not qualify as businesses that this loan is directed towards. So they would not be eligible. And additionally, any business that's engaged in any activity that is illegal under federal, state, or local law also would be ineligible for receiving the PPP loan. There's not a lot of those businesses here in Idaho, but what immediately comes to mind for me is all the states that have authorized marijuana production and transportation. In those states, it's legal, but it still remains illegal under federal law. So those sorts of businesses would not qualify for the PPP loans. The SBA also directed the rate and the term of the PPP loans. So the interest rate will be 1%. Initially, they said it would be 0.5%, but the final rule that came raised that to 1%. The purpose was to attract lenders, to make it attractable to lenders. Virtually every lender in the country is authorized to make these loans. And so by increasing that rate a bit, they made it more attractive to the lenders to participate. And the term for repayment of the loan is 2 years from the date that you get the loan. Again, many of these loans will be forgivable, but if for some reason there's some portion of it that isn't forgiven, you have approximately 2 years to pay it back. Payments on the loans, of course, are deferred for 6 months, so you don't pay anything for 6 months. By then, if you are getting forgiveness, the forgiveness will have been granted. You won't ever make any payments on those loans. The other restriction that the SBA included in the rule is while the statute allows the funds to be used for the payroll costs, the interest expenses, the lease payments, the SBA rule limits the use of those funds for non-payroll purposes to 25% of the loan amount. The goal of the loan is to keep people employed, keep people paid, and so they've added that restriction that there's no ratio in the statute of how much you can use the funds for non-payroll purposes. But for purposes of forgiveness, the SBA has said that only 25% of the funds could be used for non-employee expenses. If for some reason you miss that ratio, or you use the funds for some just completely unauthorized purpose, there's a couple of penalties for that. First, you have to repay that portion of the loan. And then secondly, depending on whether you had a full and complete understanding of the fact that you were using it for unauthorized purposes, there may be some fraud charges and that sort of thing. That's the purpose of the certification in the loan application, that you will only use it for authorized purposes. If you don't, there's penalties. The additional piece on loan forgiveness is it can be reduced. So even if you fully qualify for all of the loan to be forgiven and otherwise not have any payments at all that need to be made, the forgiveness amount can be reduced in two ways. Well, three, I guess. One is not using it for authorized purposes. Secondly is by reducing your staff levels. So if for some reason you terminate employees and don't hire them back, then the loan forgiveness is reduced in a proportional amount by how many employees you terminated. So for instance, if you have 10 employees, at the beginning of the period you terminate 2 of them, then the loan forgiveness will be reduced by 20%. The issue is if you rehire employees prior to June 30th, so you restore your staffing levels before June 30th, then you would still qualify for the full forgiveness and the reduction doesn't apply. You don't have to rehire the same person. It's just as long as you rehire sufficient individuals to get your staffing levels to what they were before. Of interest to that is the termination period is February 15th through April 26th. So if you terminate employees now, then get your loan, the PPP loan later, then if you don't replace those employees before the end of June, then you would have your forgiveness reduced by however many employees you terminated. So that's the timing of that sort of decision, and rehiring is an important thing to consider. Additionally, the reduction can come through reductions in salary. So you don't reduce the number of employees, you're just reducing what the pay levels are. Those, again, as long as you reinstate them by the end of June, you wouldn't have a reduction. And the reduction doesn't kick in until you've reduced it by at least 25%. And then the reduction kicks in and basically matches pro rata on the forgiveness side the amount of reduction above 25%. So you have a sort of a slush fund, I guess, of 25% that you could reduce if needed. I think that's really it as far as updates to the CARES Act go. The banks are still working through the guidance that they got from the SBA. I know on Friday was the date, this past Friday, April 3rd, that the SBA had announced that lenders would start processing the loans. Almost every lender has not started processing the loans. There are some who accepted applications, but then essentially put pause on that application until the SBA guidance was actually issued and the banks could work through the process. Some of the issue that are still remaining for the banks is the back end. Once you request forgiveness, then what happens? There's some guidance on that in the SBA rule that came out, but that's still an open question for some of the banks. And so they're trying to get that nailed down before they start issuing the loans. So once, if there's additional guidance that comes from the SBA or additional information that we learn from the banks, we probably will set up an additional quick course just outlining those things. I did see there's one question on the group chat of how to access the previous Zoom meetings that we've had. Those have all been posted on the firm's Facebook page. Additionally, there's a YouTube channel for the firm that they're all being posted to as well. And I believe a link to that YouTube channel has been put on the firm's website, which is www.angstman.com. So you can access all those additional videos, any of those sources. Of course, if you can't find them at any of those places, email our marketing person, Kyla, Kyla, at angstman.com. She can provide the videos by email as well. Hopefully this has been informational for people. I encourage you, all of you will get a copy of the video emailed to you as well. Encourage you to send it out to anybody that you know that could use it, whether it's friends, colleagues, it doesn't really matter, anybody that you think could use the advice. And again, we're always happy to answer questions. Thank you for tuning in. We'll see you next time.